Hi everyone. In the last class, we discussed about identifying weaknesses. So in that, we came to know about who is a weakness and what are the types of weakness and what is the importance of weaknesses. Then next we will check what are the procedures for the examination of a weakness. So for calling the witness to give the give the or to testify in the court of law, the court will send some letter to the witness. That document or letter is called as summons. So summons or subpoena is a document commanding the attendance of a witness in court of law. It is issued by the court in writing, signed by the presiding officer, and is served on the witness by a police officer or an officer of the court or any other person specifically authorized for the purpose. So after receiving the summons, the witness or the person is in, like he must obey the summons, and he should appear before the court on that particular date. But if there is any valid or urgent or emergency reason is there and he can't go on that date, he can ask for the permission of the court, and he should report to the court that some because of this reason I can't come there on time on that date, so please give me an extension date. Like that he should report to the court. If at all the witness is not obeying and he willfully avoids the summons to appear before the court, he is guilty of contempt of court. In such cases, the penalty for that disobedience is a warrant of arrest and a compulsory appearance before the court. This is mentioned in the section 84 CRPC. The punishment prescribed for that disobedience is an imprisonment for a term which may extend up to 1 month, or fine which may extend to rupees 500, or both. This is mentioned in 174 IPC, section 174 IPC. So the person who receives the summons is should obey the court order, and he should appear before the court on that time. And if he is having any emergency situation, he should report to the court for and ask permission for the extension. If he willfully avoids the summons, then penalty is warrant of arrest, and it is mentioned in section 84 CRPC, and the punishment is imprisonment up to 1 month, extend up to 1 month, or fine, or both. This is mentioned in section 174 IPC. Next is conduct of money. For appearing before the court, and that travel expense and other expenses of the witness is they will pay to the witness. So it is mentioned in the Code of Civil Procedure. This is applicable only for the civil cases, and in no criminal case the witness is paid, because in criminal case if the person is or summoned for giving the testimony, then it is his duty or responsibility to appear the court. But in civil cases, if a person is summoned to give a testimony, then the party applying for this some applying for summoning a witness shall pay to the court all the travel expenses and other expenses of the person, if the witness is a common or ordinary witness. But if the witness summoned is an expert, then the court will give him a reasonable remuneration for the time occupied for both giving evidence and performing any other work. So this money is called conduct money. The money paid for the witness is called as conduct money. Next, after receiving this summons, the witness will appear before the court. So in court, what all things are happening. So next we will see the procedure in court. First one is oath, next one is examination in chief, then cross examination, and then re-examination. So first one, oath. Once the witness is summoned, makes his appearance in court, his evidence is recorded after the administration of the oath only. This is mentioned in the section 138 to 159 IPC, and in Indian Oath Act section 2, 4 and 6. So what is an oath? After administration of oath only he can give the evidence. So what is an oath? Oath is a declaration required by the law to be made before the court by the witness. It states like this: I swear in the name of God that the evidence I shall give to the court shall be the truth, the whole truth, and nothing but the truth. So help me God. If the witness is an atheist, he makes an affirmation as follows, like I solemnly affirm that the evidence I shall give to the court shall be the truth, the whole truth, and nothing but the truth. If once a witness has been sworn, he is liable to be prosecuted from perjury. Perjury means giving willful, false, or fabricated evidences. So, after taking the oath, if while giving the evidence, he should not give any false information or he should not fabricate the evidence. He should tell the truth only. If the court found out that he is fabricating the evidence, he is liable for perjury, and the imprisonment may extend up to 7 years. This is mentioned in the section 193 IPC. And perjury is defined in sections 191 and 192 IPC and 344 CRPC. Punishment for perjury, imprisonment may extend up to 7 years. It is mentioned in section 193 IPC. Next one is chief examination in chief. Examination of a witness by the advocate of the party which has called him. Examination is the chief is the examination of witness by the advocate of the party which has called him. In government prosecution cases, the public prosecutor commences the examination in chief. Then leading questions are not allowed here. Leading questions means the question in which itself suggests the answer. For example, we can say that the advocate is asking a question like to the expert that does the injury caused by a sharp weapon, like was the injury caused by a sharp weapon, like that. So here only the answer is there. This is called as leading question. Normally, the question should be phrased in this manner like, Doctor, what weapon has this injury been caused? But instead of that, he asked like, Doctor, was not the injury caused by a sharp weapon? These kind of questions are called leading questions. So, these leading questions are not allowed in examination in chief. Next is cross examination. So followed cross examination is followed by examination in chief, and this examination is the examination of the witness by the opposite party. Earlier, the examination in chief was done by the advocate of the party which has called him. Cross examination is done by the opposition party's advocate. Then the purpose of cross-examination is to highlight inaccuracy and contradictions in the statements of the victim and thereby to prove the court that this evidence is not valid. Here the leading questions are allowed. So the witness must therefore he must be very careful in answering the questions. He may be asked questions to test his truthfulness, skill and character. A medical witness must not feel insulted, must avoid losing his temper, and must answer the questions with dignity, and it should be very clear, because the purpose of the cross examination is to prove to the court that this evidence is not valid. Then re-examination. Re-examination is followed by cross examination, and it is conducted by the counsel who has conducted the examination in chief. And the purpose of the re-examination is to clear any doubts that may arise during the cross-examination. Here the leading questions are not allowed. So these are the 4 steps: oath, examination in chief, cross-examination and re-examination. After these 4 steps, if again some doubt is there to clear, then the court asks questions. These questions are asked or put forward by the presiding officer of the court. This is only for clearing the doubts. These are the procedures of examining a witness.